The European Court of Justice, formerly just the Court of Justice, is the Supreme Court of the European Union in matters of European Union law. As a part of the Court of Justice of the European Union, it is tasked with interpreting EU law and ensuring its equal application across all EU member states under Article 263 of the Treaty of the Functioning of the European Union. The court was established in 1952 and is based in Luxembourg. It is composed of one judge per member state, currently 27, although it normally hears cases in panels of 3, 5 or 15 judges. The court has been led by President Koen Lenaerts since 2015. The ECJ is the highest court of the European Union in matters of union law, but not national law. It is not possible to appeal against the decisions of national courts in the ECJ, but rather national courts refer questions of EU law to the ECJ. However, it is ultimately for the national court to apply the resulting interpretation to the facts of any given case, although only courts of final appeal are bound to refer a question of EU law when one is addressed. The treaties give the ECJ the power of a consistent application of EU law across the EU as a whole. The court also acts as arbiter between the EU's institutions and can annul the latter's legal rights if it acts outside its powers. The court was established in 1952 by the Treaty of Paris, and the European Atomic Energy Community were created, sharing the same courts with the European Coal and Steel Community. The Maastricht Treaty was ratified in 1993 and created the European Union. The name of the court did not change unlike the other institutions. The power of the court resided in the community pillar. The court gained power in 1997 with the signing of the Amsterdam Treaty. Issues from the third pillar were transferred to the first pillar. Previously, these issues were settled between the member states. Following the entrance into force of the Treaty of Lisbon on 1 December 2009, the ECJ's official name was changed from the Court of Justice of the European Communities to the Court of Justice, although in English it is still most common to refer to the court as the European Court of Justice. The Court of First Instance was renamed as the General Court, and the term Court of Justice of the European Union now officially designates the two courts, as along with its specialized tribunals. Taken together, the Court of Justice consists of 27 judges who are assisted by 11 advocates general. The judges and advocates general are appointed by common accord of the governments of the member states and hold office for a renewable term of 6 years. The treaties require that they are chosen from legal experts whose independence is beyond doubt, and who possess the qualifications required for appointment to the highest judicial officers in their respective countries or who are of recognized competence. In practice, each member state nominates a judge whose nomination is then ratified by all other member states. The President of the Court of Justice is elected from and by the judges for a renewable term of 3 years. The President presides over hearings and deliberations, directing both judicial business and administration. He also assigns cases to the chambers for examination and appoints judges rapporteurs. The Council may also appoint assistant rapporteurs to assist the President in applications for interim measures and to assist rapporteurs in the performance of their duties. The post of Vice President was created by amendments to the Statute of the Court of Justice in 2012. The duty of the Vice President is to assist the President in the performance of his duties and to take the President's place when the latter is prevented from attending or when the office of President is vacant. In 2012, Judge Koen Lenaerts of Belgium became the first judge to carry out the duties of the Vice President of the Court of Justice. Like the President of the Court of Justice, the Vice President is elected by the members of the court for a term of 3 years. The judges are assisted by 11 advocates general, whose number may be increased by the Council if the court so requests. The advocates general are responsible for presenting a legal opinion on the cases assigned to them. They can question the parties involved and then give their opinion on a legal solution to the case before the judges deliberate and deliver their judgment. The intention behind having advocates general attached is to provide independent and impartial opinions concerning the court's cases. Unlike the court's judgments, the written opinions of the advocates general are the works of a single author and are consequently generally more readable and deal with the legal issues more comprehensively than the court, which is limited to the particular matters at hand. The opinions of the advocates general are advisory and do not bind the court, but they are nonetheless